Del papel del jurado en los casos de pena de muerte. Está actualmente participando en la investigación, como fue recientemente referenciado, sobre la introducción de juicios por jurados en Argentina en diversas provincias y de la participación ciudadana en otros países como Japón, Corea, Rusia, España y Taiwán. Así que sin más, le vamos a brindar todo el tiempo a Valeri Hans. Bienvenida nuevamente. Un honor escuchar.
Thank you. I am so delighted to be here today to share some of the results of an empirical project on trial by jury in Neuquén. I first want to set a little background about why it is that the courts in Neuquén and the staff and others supported empirical research. One of the main purposes was to learn how this new democratic experiment was going. How are jurors who are unfamiliar, as you would see with trial by jury, how are they coping with this new challenge? How are lawyers managing a different approach to arguing a case before a jury? And how do judges who are used to being completely the judges of the law and the facts, how are they managing this new approach? Learning all of these things could be very, very helpful. It might point to the way the system is working well, but it also could point out for those who are involved in the practical details of trial by jury, what needs to be strengthened, what needs to be changed, what needs to be improved. There is another benefit, I think, to this empirical study, and that is that we can share the results. All of the people who have been involved in the project can share the results with other people, not only with the courts in Neuquén, but also with people from other provinces who have adopted trial by jury or are considering new trial by jury. Finally, for me as a researcher of jury trials in different countries, it's an amazing contribution, I think you will see, to world knowledge about trial by jury and about the features of systems that effectively use lay citizens as legal decision makers. So there's much to recommend an empirical study like the one that we and others have been conducting in Neuquén. It's quite a large group of people who have been able to make this a successful project. Carla Pandolfi being one of them, Leo, of course, the amazing judges who have been so supportive in allowing complete independence of the research, and that's important. You want some distance between the people who are part of the system and the people who are studying the system. But you can see here just some of the many individuals who have participated. On the research side, you will hear some of the people who have been involved, including Sidonie Porterie and Andres Hartwig from UNICEF, which has been a major contributor to our research project, and other investigators who have been studying trial by jury. You'll hear later from Sherry Seidman-Diamond, who will talk about other results pertaining to judges and how they have been looking at the new system tomorrow afternoon. It's been a great group of people, and I think we've been able to look at many dimensions of jury trial as it has been developing in Neuquén. So what have we been doing? We have been taking information, getting information about trials, jury trials in Neuquén from many sources. We have observed the videos of the trials because Neuquén records the trials for later review. We have, at the end of each trial, we have had people from the court describe some of the details of what went on in the trial, the charges, the evidence that was submitted to the jury, and so on. And the centerpiece, though, are questionnaires that we have given to the jurors after trial, and also to the judges and to the lawyers, including fiscales, defensores del niño, y querellas. In the number of trials that we have looked at, we have now a total of 17 cases over the last couple of years, with 200 jurors and something a little, I think all the judges have participated, thank you judges, and many of the lawyers, most of the lawyers have also participated to share their reactions to what their experience is in jury trial and what they need more. The trials mostly were in the city of Neuquén, although we have a handful outside the city of Neuquén, and most were homicides, and most resulted in convictions. And I think that's something that is worthwhile as you look at some of the other responses that I'll be sharing with you later on in the talk. To know that these were the types of trials, very serious cases, but most resulting in a conviction. Most trials lasted a week or less, and the voir dire jury selection, which I know is unfamiliar in a country where there has not been much in the way of jury trials, was fairly short, between about 30 minutes and 2 hours. So you have a bit of a sense of what these trials looked like. So who comes to serve as a juror when you summon them? It's very interesting to get a picture from those people who encounter a system that most, it turns out, have never heard of. We had a range of ages, as you can see here, representing people from the age of 21 up until the age of 71. There was also a range of educational levels. This right here contrasts the education levels of individuals who served on juries in Neuquén over these 17 trials with some government data about the education levels of the population of the province. And one of the things that you might notice right here, over here, is that people without much education tend not to be as fully represented on the jury. And I will say, in looking at juries in the United States, that's very, that is common, that juries tend to be, on the whole, somewhat better educated than the population as a whole. Yet you also see, I think, if you look across, there is a big range. There is a big range. So the juries as groups would reflect a broad range of the population, even though they might not be perfectly representative of the population. Most jurors were employed. The majority of jurors had some sort of occupation and were working, most of them full-time, and were of mid-range in what they reported as their economic situation. So knowing now a bit that you have a representative group from the province of Neuquén that's not perfectly representative but still quite robustly diverse, what do they think about trial by jury? What happens when they are first called? We asked the very first question: how much did you know about the system when you were first summoned for trial by jury? And what you can see here is that the vast majority knew nothing about the system. And the rest, most of the rest, knew just a little about the system. So the trials lasted from 2016 up through 2018 in our group of trials, the 17 trials. You heard the governor speak about the new initiative of adding to the school curriculum information and projects about trial by jury. And I think what you can see is that it's very a good idea. It's a really valuable idea to communicate to at the school level, where you have people to communicate in a coherent and educational way about trial by jury. And so that's a really big step forward. My guess is, as we look in future cases, we will see many more people knowing about trial by jury when they get the summons and when they come to the court. Middling level of enthusiasm about taking on this new job. We asked them, what were your emotions when you were summoned for trial by jury? And as you can see, there's a range, with some people enthusiastic and some not so much. We also asked them, were you annoyed? And actually about half said, no, I was not annoyed. I think intrigued and interested for many of them. So you have a group of people that know virtually nothing about the system. They're not quite sure what to make of it. What happens when they enter the courtroom and begin this new task for which they have, at least at this point, very little background? One of the big questions, and the Justice Rosati, of course, wrote an entire book on this very subject, is whether or not people drawn from all walks of life are competent to decide the case, to evaluate the evidence, to reach a decision that's consistent with the law. And so one set of our questions in the questionnaires to the jurors and to the judges and to the lawyers is, what about difficulty understanding the parties and the judge and the instructions, the testimony of witnesses that was given, the law that you had to learn. And here, you find jurors actually behaving very similarly and reporting a very similar kind of approach as we have in juries in the United States. So for example, most jurors say they don't have problems understanding the judges and the lawyers for both sides. You see here on the slide, very high proportions of jurors saying, no, I did not have a problem. And I think that's interesting because it also suggests the lawyers are working hard and the judges are working hard to communicate what needs to be communicated about each side and the law that must be applied to the case for the juries to decide. They also report that even though the cases range, some were more complicated, some were less complicated, that generally they did not have problems understanding the evidence in the case, the proofs in the case, the testimony, to understand evidence, the difficulty they experienced in understanding the testimony that was given by witnesses, they felt was, most people said, no, we understood what was going on. And the satisfaction with how the trial was conducted was high, and the judge's instructions about how to proceed and what law to apply were also judged to be very, very helpful. So, I gotta say, I was very intrigued by these data because I've been studying all my life a system that has been in place for a few hundred years. And here is a system that has been in place for a couple of years, and yet the citizens, when they are called to do so, really put lots of effort into comprehending, and it looks to me like the legal actors also put a lot of effort into trying to communicate clearly. So I think that's congratulations to the jurors, but also to the legal actors who are such an important part of the success of this project. One of the things about trial by jury that is most intriguing is that jurors deliberate, but they do so privately. And they move themselves into a deliberation room and discuss the case amongst themselves without anyone else around. And there are a number of reasons for that, but the biggest is to protect them from influence, outside influence, to make a secure environment in which they can debate freely, and also not have people telling them what to do. So the classic jury that Neuquén has introduced, in contrast to the mixed courts in Cordoba, preserves this complete independence during the deliberation. So one of the values of our questionnaires was we were able to ask our jurors, the jurors in these trials, how was the deliberation? And again, here are people who have not participated in deliberation, and maybe their experience with deliberation is limited to watching movies of U.S. courts and so on. So how did they do? The first interesting thing we wanted to look at was what they did in selecting someone to lead their group discussion, the presiding juror, who communicates with the judge what the verdict is, passes along any questions, and so on, and helps to guide the jury's deliberation. Now here in these 17 trials, we find a close to even split between men and women. 10 men and 7 women were chosen by their groups as jury leaders. One of the interesting things is they tended to be people who are in the workforce. They have somewhat more education, although there was a wide variety of occupations included in the jury leaders. But it was good to see, given the fascinating quota system for gender, half men, half women, that our judge in the first session was noting that we have good participation by both women and men as jury leaders. And one of the things that we hope to do going forward is to see how these groups might differ or how they might be overlapping in deliberation. We asked whether or not people, again, with little background, had time to express their perspective, their point of view. And most people were in agreement. You can see here that the agreement is very strong. Most of the jurors going into the deliberation room reported that they had plenty of time to give their perspective on the evidence in the case. They also said that they listened to other jurors. And virtually all people, again, reported that they listened to other jurors. And again, these are the kinds of things you want to look at when you're trying to evaluate whether or not the deliberation is functioning well. You want to make sure that people feel the opportunity to express their point of view and to hear from others, because the deliberation is one of the ways in which the jury, the collective, is stronger, because the deliberation offers this opportunity to exchange points of view, correct misunderstandings of the evidence, and help one another grapple with some of the important issues confronting them. One concerning thing that we found in some juries is that it looked like maybe 30% or so, about 1/3, had some very strong individuals. One or two, we asked people whether they agreed or disagreed that one or two people on the jury dominated the deliberations, took more than their fair share of time during the deliberations. And we did see that in some deliberations that was the case. This next slide shows the proportion of jurors who said they spent a certain amount of effort trying to convince other people. And I want to point this out because jury systems in Argentina now have different varieties. There are different procedures and qualifications and characteristics. And Neuquén chose a majority jury, whereas Mendoza, as you know, has just started and requires unanimity, as does Buenos Aires province. And so what you see here is that in about half of the trials, there was no effort to try to convince other jurors. Now, I think this number will be very different in the cases where unanimity is required. One possibility is that juries came in and everyone agreed right away. That's true for some of the cases, but definitely not all the cases. So I think this pattern is what it is because of majority decision rule. So we see some of the strengths of deliberation. We also see some ways in which we would like to look further at the kinds of cases in which one or two members seem to dominate or not much effort is used in trying to convince other people. But on the whole, as you can see from this next slide, most of the jurors are very satisfied with the results of the deliberation. They are supportive of the conduct of the trial and the deliberation. Now, one of the questions that we want to ask, and we will explore more in the future, is how the deliberation might be a different experience for people, for men and women, and for people with more and less educational levels. So that's something that we have looked at quickly. One of the things that we see is very, very similar participation, self-reported participation by men and women. So this is not always the case in the United States, although it's gender and women's participation, reported participation, and leadership of the jury has improved over time in the United States. But this was very reassuring when we asked people about reporting how much they were able to participate. The men and women of Neuquén's evenly divided juries report very similar kinds of responses. We do see a little difference for people with very low levels of education. And what I did was, in our analysis, was to contrast people who had less than a secondary level of education and more. So about half of the, so jurors with less education and more education. And what you can see here are some differences that come out that I guess do make sense. People with lower levels of education report, wrong button. Let's get back. They report somewhat less participation, which again might make sense if you're thinking of them as not having the kinds of jobs or other environments or being exposed to other environments where they are used to exchanging and making group decisions. So that's really a possibility. I also was intrigued because in addition to reporting less participation, people with lower levels of education were also more likely to say that, let's see, over here, that one or two members dominated the deliberation. So there was this perception that there was a bigger difference among people who were at lower levels of education. So, how do jurors feel after they have served? Here are, to me, some of the most exciting and also reassuring results about the experience. And that is when we asked jurors, how is your evaluation compared to what you initially expected about trial by jury? If you remember, they knew virtually nothing about trial by jury, and so they came to it with, I think, probably mixed expectations. But what you see here is that most people came away from their jury experience much more favorable about the jury system and their own experience. It was a better system, a more positive experience than they had thought it was going to be. They reported little frustration, which is interesting. Very few people said that they were frustrated by the experience. And if you remember back, with their initial kind of reaction when they were summoned for jury trial was some of them felt annoyed about the summons, but they served, they participated, and they came away with this more positive view. And in kind of retrospect, the frustration level was very, very low. Instead, they felt pride in participating as jurors in this democratic experiment that neuquén has pioneered here. A great deal of pride. And this is something for the governor and for the courts and for the judges. They also came away more positive about the jury system itself, which, they started from virtually nothing, so that's good. That was in the right direction. But also the courts and the government. The neuquén government, which is fascinating that an experience as a juror could actually extend to a government, and even to the police. So because these were homicides, police often testified. Now, you see lower numbers there for the government and the police. Not that many people came away with negative experiences. They reported either no change or a more positive change, even in those last two categories where the numbers are not quite as astonishingly high as they were for the jury system and the court system. The overall response, as you can see here, is that people participated actively as jurors in this, what for them was a new system, and came away with either no change or more confidence in the courts, in the government, and in the police. We have seen some of the same kinds of experiences in other countries. One of our collaborators, John Gastile, has studied thousands of jurors in the United States and finds that in the United States, after jury service, people are more active in civic, they are more civically engaged. Unlike Argentina, the United States does not have mandatory voting. And so what John Gastile and his collaborators have found, she's going to show John Gastile's book available over there in the corner. One of the things he discovered is that people following their jury service are more likely to vote in the next elections than they were before their jury service. So it's fascinating. Participating in this civic experience with other citizens and making a contribution to the justice system appears to energize people and connect them more with their community. So in a way, it helps to build a democratic, self-governing system. And this is happening, we see evidence from these results that this is happening here in neuquén, just as it has in other countries. One other thing we asked them following the jury trial was whether they would recommend the experience to other people. why they would do so. And you can see here some of the categories they relied upon to explain why the vast majority thought of it in a positive way and would recommend it to other people. It's the possibility of observing and knowing and learning about the system of justice. So the kind of educational component of participating as a juror. And also the action of participating directly in trying to do justice and improve the quality of the institutions around us, the government institutions around us. So those are some of the reasons the jurors gave for having a positive experience and wanting to recommend it to others. There were some wonderful quotes that we drew on, and I will let you read them, about why they felt so strongly and so positively about the very, very positive experience. What you see is in line with these overall categories. It's a good experience in part. You have a chance to contribute to the justice system directly in a way that without a jury system, there are very few methods of employing, of doing. Okay, I want to have a few moments we've heard from the jurors now, and overall, their experiences are really very, very positive, in line with the experiences of jurors around the world. But what about the legal actors? Now, here, what I will talk about is just a handful of results from the lawyers from both sides who filled out questionnaires for us in our 17 cases. And tomorrow afternoon, Sherry Diamond will share some of the responses from the judges who presided over those trials. So you'll get right now a kind of picture from mainly from the lawyers, and tomorrow the bookend will be to hear from the judges and their perspective, their views and perspectives on trial by jury in neuquino. One of the interesting things is that having to argue a case before a jury is an intriguing challenge. I mean, instead of handing a pile, forgive me, but handing a pile of papers to a judge and saying, see you in a few months, which is more a civil law system way, is so different from oral advocacy and not even oral advocacy before a person who has been trained in law, like you have been. Instead, you are talking to a group of people who have very little experience with law. And so it was interesting to me to hear that lawyers were mixed in terms of the approach they took to trying to litigate a case before a jury. I think what you can see here is that when we asked, did it kind of change the litigation of the case before a jury as opposed to a judge, right? You see a kind of mixed. Some lawyers, fiscales in particular, don't see the change so much, but defense attorneys tend to see the change. And part of it may have been that some of the lawyers felt that this was not necessarily a good case before the jury. You see most people, like half of the defense attorneys and 9 of the 16 prosecutors who answered our question said it was a good case to resolve before a jury, and the others said no, it was not a good case. But just remember, the defense lost many of these cases. So they were answering the question after their sad loss at the jury trials. So that's important to keep in mind. The concept of voir dire is unusual, but I think most of the lawyers on both sides and the jurors who were in the deliberation room with the other jurors thought that even the very limited voir dire that was done was generally effective in identifying people who should not be sitting on the case because of they had prejudged already or would not were biased in some way or could not serve for other reasons. Most of the jurors, the majority of the jurors thought also that the voir dire was effective. And that is remarkable. I think a longer voir dire with more specific questions could probably increase these numbers about the effectiveness of voir dire a bit more. And I understand there will be some training in voir dire in not only Neuquén but other provinces going forward. Now, the fascinating thing, you remember jurors themselves thought, yeah, we understand the evidence in this case, we understand the proof, the testimony, the judge's instructions, and so on. We wanted also to ask the legal actors what they thought about competence of the jury. What you see, remember we have 17 cases, and mostly we have about 16 prosecutors and 16 of the people who were representing the defense. Mostly they approve. And again, sometimes these people are losing their cases. So that's maybe when they think, oh no, they don't understand my case. That's one of the things that we'll continue to look at. It would be interesting to know, in cases that you lost, do you feel the reason is because jurors didn't understand the proof, or did they understand it all too well? Also, the law was, at least according to these legal actors, also the jury seemed to have a good handle on the law that was applicable in this particular case. We asked whether or not they thought that all the evidence that was necessary to be presented at a trial had been presented at a trial. And I want to first draw your attention to what the jurors said. The jurors, just half of them said, yes, we had sufficient evidence to be able to decide this case. About 1 out of every 5 jurors said no, I would have wanted more evidence in the case. And in other work that I have, and my collaborators have done with juries, they often say, I would have wanted this evidence. It would have been great to have this piece of information. But trials are imperfect. Not all evidence is there. There are some legal reasons, of course, for withholding other evidence. So that's understandable. You see, though, when you look at the prosecutors and the defense attorneys, that the defense attorneys seem to be more concerned that they didn't have sufficient opportunity to present all the evidence that they believe was necessary in the trial. So I think that's an area where we can explore that and look to see what kinds of things might be done so that jurors themselves and attorneys feel they have a really full opportunity to present the most convincing case to these fact finders. When we asked lawyers, what do you want? What do you need, to be better the next time around? The prosecutors in Neuquén, especially Neuquén City, have often been very experienced and have had multiple trials. Many of the defense attorneys were trying their first case, the first trial they had ever had in jury trial. And what you see in the comments that we have captured here, just a few comments, is that many of them really would like more training. They feel that they would like to learn from others with greater experience, either within the province or perhaps outside the province, about the best techniques for voir dire, the best techniques for questioning prospective jurors, the best techniques for presenting opening statements, closing arguments, and a sequence of evidence that will make a coherent story for the jury. In this new jury system that the attorneys themselves believe that this is very important, and I think you are already planning on training, and I think the lawyers who have been on the front lines here would reinforce that desire, reinforce that need for more training. So I want to close with just a few short conclusions and leave a little time for questions that you might have. It's early, there's more work to be done, but I think there are many very positive pieces of information that the empirical study has uncovered that suggest trial by jury in neuquén is doing well. We have jurors who initially don't know anything about jury trial, yet join the role of juries and the new role that they have, the new unexpected role that they have, and do so with enthusiasm and care. And they come away from it with a kind of greater sense of wanting to be involved in the democracy that they are part of. So they are moved by the experience and more positive about the courts, and that positivity transfers to the general democracy within which you are all living. I was also really struck, and again, it's because I study an old system, to see so many overlaps and similarities with a new system. That the competence, the reflection that basically the trial was understandable, that they were capable of making a good decision in the case, the reinforcement by the parties that they also saw the jury as basically competent. Those are the kinds of things I think that I see also in other research projects around the world. You will hear later in this conference about new jury systems in the former Soviet countries. You will hear about the fascinating work in Japan for mixed courts, and I think you will begin to see there are some really intriguing and important similarities about bringing people from the community in to serve as lay judges in these whole variety of cases. And so we can really learn, I think, from this experience in neuquén, not only what kinds of things are strong about the current project, but also some points where more training is needed, perhaps examining procedures or approaches to jury trial can also be improved. I am so grateful that I've had a chance not only to participate in this project, but also share these results of the year and a half of jury trials in neuquén with you. Thank you.
Bueno, los que quieran realizar preguntas, hay un micrófono disponible, levanta la mano y adelante. Doctor Lucero.
Muchas gracias, Carla. Valeri, dos puntos. El primero, en relación a lo que se ha indagado en la investigación, hemos escuchado que se ha analizado el nivel de comprensión por parte de los jurados de las pruebas, por ejemplo, y también de las exposiciones de las partes. Teniendo en cuenta que al final hubo un defensor que dijo que se necesita mayor capacitación en oratoria, la pregunta es si se ha indagado en qué medida los jurados no solo comprendieron, sino llegaron a ser persuadidos por la argumentación de las partes. Persuadidos. ¿En qué medida se vieron persuadidos? ¿O en qué medida advirtieron que ante una muy buena oratoria, esa oratoria no llegaba a ser consistente con la información producida en el juicio? Ese es un punto. El segundo punto, en la información que da cuenta que el 44% de los jurados no tuvieron ningún esfuerzo en convencer a los otros para llegar a una decisión. ¿Qué opinión tienes, Valeri, respecto del modelo neuquino? ¿En qué medida sería conveniente elevar el mínimo para la acusación, que es de 8 votos, y llevarlos a unanimidad, al menos en los casos que importen prisión perpetua?
Gracias, Gustavo.
Thank you very much for your questions. Yeah. On the question about jurors being persuadable versus paying attention to the evidence and seeing what it says as opposed to what the lawyer says. I think most of what we know from research in the US is that the evidence and the interpretation of the evidence is extremely important. So if a jury is in a case where the evidence is very strongly tilted toward one side, the verdict is virtually always going to be in favor of that side. And it doesn't matter how good the lawyer is, right? If there is a case where the evidence is very closely divided, and the lawyer is excellent and might have an excellent argument, I could see perhaps it might make a difference. But juries are really driven by the evidence in the case and their interpretation of the evidence in the case. First, their own individual interpretation of the evidence, and then the evidence discussion in the deliberation, where they test each other, engage in discussion and deliberation, vigorous deliberation in most cases, right? So I would say lawyer persuasion can help in some ways, but not if the evidence does not support it. So that's your first point. But it's related also to the second point about the effort. I am not totally sure, but I believe the effort is in part because many juries were already strongly of one mind when they came to deliberate. So that's one thing. And second, because juries were not required to reach unanimity in these neuquin cases. You asked for my opinion, and I'm glad to give it, even though provinces make their own choices about what kinds of systems work well for them. In studying majority juries and unanimous juries, generally the deliberation is more robust in unanimity. So if you require someone, a group, to be unanimous, they will work harder in most cases. That's what we know from other research. And I think the lower effort to convince other people is a result of that. So unanimity requirement for the most serious cases, might make sense. It would have the positive effect of more robust deliberation and more effort to convince everyone about the case. It may also be seen as more legitimate in the eyes of the public to have everyone on the jury agree unanimously about an outcome, a particular outcome, whether it is guilty or not guilty. The negative side of deliberation, of unanimity, is it slightly increases with small numbers the likelihood that the jury wouldn't be able to agree in some cases. So that's the trade-off between a unanimous decision rule and a majority decision rule. I hope that answers your question. Yeah.
Doctor Inaui.
Hola. Valeri, junto con Pino Russo, que está presente aquí adelante, éramos diputados que integramos la gestión que sancionó el Código Procesal Penal de la provincia, que incluyó el juicio por jurados. Fuimos miembros informantes de esa norma. Al momento de su sanción, fuimos muy mezquinos a propósito a la hora de establecer la competencia de los juicios por jurados, y establecimos, más o menos calculando, unos 10 juicios por jurados al año que pudieran llevarse a cabo, toda vez que desconocíamos hasta las implicancias presupuestarias que iba a traer aparejada la realización de esos juicios. Después de ver tu informe y después de 5 años de vigencia de esta normativa, de la realización de 44 juicios por jurados en la provincia del Neuquén hasta el mes pasado, me gustaría saber tu opinión sobre la posibilidad de ampliar la competencia de los juicios por jurados, de ser más generosos en la implementación de este tipo de participación ciudadana en la administración de justicia, y de incluir nuevas figuras penales para que sean juzgadas por jurados populares. Me parece que después de 5 años la provincia de Neuquén ya se ha puesto, no sé si los pantalones largos, pero sí se ha recorrido un camino que ha sido difícil, pero creo yo ha sido muy exitoso. Querría saber tu opinión, a ver si podemos ser ya a esta altura más generosos en relación a la competencia del juicio por jurados.
I think you are right to find support in the research data that for expansion. So there is general support for the idea that juries are doing a good job and the small number of cases that have confronted them so far. And I think when you see that participating as a juror has important effects for democracy, for confidence in the courts, bringing more people to that experience, expanding the number of people who could participate directly as jurors and tell their friends and neighbors and co-workers about the positive experience would be a positive outcome as well. So good luck in your legislative efforts to expand trial by jury in Neuquén.
Doctor.
Gracias. Sebastián Videla, del Ministerio Público de Provincia de Buenos Aires. Valeri, buen día. Quería preguntarte si en los casos que ustedes habían analizado llegaron a encontrar si había alguna clase de evidencia que hubiera sido más determinante o más importante para el jurado para llegar a un veredicto. Si los testimonios o la prueba científica, por así decirlo, habían tenido más peso. Si había algún elemento en particular que había tenido más peso para arribar a la decisión del jurado.
Do you mean, I must ask you, let me follow up. Do you mean that because these were very serious cases, the jury felt compelled to reach a verdict?
Yes.
Okay, all right. So this really, I'm listening to the Spanish. So this really speaks to the idea of expanding. Yeah. I think if the expansion, as was proposed, to a broader range of cases would make sense. I think in other research we have seen that juries generally bring a great deal of effort and seriousness to their role. So I wouldn't expect there to be this decreased level of commitment if they are given this role and asked to decide a lesser case, a charge that is not as serious as the ones that you have already put before them. So.
Thanks.
Muchas gracias. Vale, y la última pregunta la voy a hacer yo. Si en las investigaciones en algún momento se tomó en cuenta, imagino que sí, el sistema de jurados de la ley israelí en relación a la unanimidad, que dice, refiere que, digamos, si el abogado defensor logra convencer al menos a un jurado de la inocencia del imputado, estuvo mal defendido.
I'm sorry, could you repeat?
Si en algún momento en las investigaciones se tuvo en cuenta la ley israelí, si surgió en algún momento, que la misma establece, no sé si sigue vigente, pero digamos, en algún momento de su historia, donde en realidad no requería la unanimidad, porque si la persona que estaba siendo juzgada y su defensor no lograban convencer al menos a uno de los jurados de su inocencia, se consideraba que el juicio, o sea, que había que una defensa decadente, por decirlo de alguna manera, una defensa insuficiente.
Okay.
¿Y cuál es tu opinión?
Okay. Might be a translation problem. I'm not understanding. Sorry. Okay. That's. Yeah. Okay, so Carla has asked me a fascinating question about a law that I have never heard of before. And it's really provocative and intriguing that unanimity, a unanimous conviction, implies that the defense attorney failed terribly. So maybe that's an argument for majority verdicts? Is that what you're suggesting?
That's what it's taught in Israeli law, and obviously I learned it from my father.
Oh,
it's not
okay.
my own friends. Okay, thank you very much.
Thank you.
Vamos
Thank you.
al